Hey guys, I'm Anshika Aggarwal. Today I am going to discuss on the topic restitution of conjugal rights. Restitution basically means to restore, and conjugal rights means rights related to the marriage or valuable relationship between husband and wife. But the basic meaning of conjugal rights is physical relationship between husband and wife. Here I will not discuss the Barrack language as this you can read from the Barrack itself. So I will discuss it in easy terms. So the restitution of conjugal right is defined in section 9 of Hindu Marriage Act 1955. The provision of restitution of conjugal rights is also available for people of other religion like Muslims, Christians. It is not so that it is only for Hindu religion people. As per the Indian law, every husband and wife whose marriage is solemnized legally are entitled to conjugal relation with their partners. Basically, restitution of conjugal rights is used as a defense tool nowadays. As earlier, couples wanted their marriage to remain intact and restored, and they think 1,000 times before getting separated. This may be due to many reasons, and the most popular reason may be what people will think of them, that they have got separated. Nowadays, couples consider marriage as a burden on them, and they have to fulfill certain responsibilities. And in case they fail to fulfill those responsibilities or duties, they think that their marriage has also failed. This is a reason that the rate of divorce has increased nowadays tremendously. So keeping this in view, the idea of providing restitution of conjugal rights by a court decree is to preserve the matrimonial tie as far as possible by enabling the court to intervene and enjoin upon the withdrawing party with the other. The husband has a right to require his wife to live with him wherever he may choose to reside. On the other hand, it is corresponding duty of the wife to live with their husband. However, there may be circumstances which compel the spouse to live in different places. These circumstances may furnish reasonable or just excuse to the wife to live at a different place. The example may be that they have they have jobs at different places, so they can't live together. It is for the court to decide as to whether the circumstance permit the wife to reside apart from the husband. Law provides that when either husband or the wife withdraws from the society of the other, the aggrieved party may apply to a court for a direction that the other party should live with him or her. This is said by section 9 of the Hindu Marriage Act. Such a petition is to be filed before the district judge. So the court is bound constitutionally to accept the petition if reasonable grounds are found. Where a question arises whether there has been reasonable excuse for withdrawal from the society, the burden of proving excuse shall be on the person who has withdrawn from the society. That is, the person has to prove that he is the real victim. Also, judicial separation is different from restitution of conjugal rights, but they are counter case. When a petition is filed in the family court where any of the spouse is staying, or where both the spouse has resided together last, or where the cause of the action arose. The court analyzes the true intention of the petitioner when the petition is filed for the restitution of conjugal rights. Court provide opportunity to the petitioner to prove that the spouse is not fulfilling the matrimonial duties intentionally, that too without any reasonable cause or any justification. Also, the petitioner has to prove that he is not at fault and he is the real victim who is deprived from matrimonial rights. If the court is satisfied by the argument of petitioner and there is no ground to suspect the petitioner and also his intention is real, then the court further sees then the court sees that there is no reasonable ground for refusing the decree. So the court gave equal opportunity of being heard to respondent also. that he should come to the court and present his or her side to prove that his or her withdrawal from the society was genuine. As this is the principle of natural justice or the alteram partem, which means right to fair hearing or hear the other side too. Then court issues summons to both the parties. So on the next hearing, the onus of proof lies on the respondent against the petition of the petitioner. When the respondent accepts all the allegations put by petitioner, then the court grants decree in favor of petitioner and give the respondent two options. That if he wants to keep the relationship intact, then he have to keep himself intact in the matrimonial tie, else file for judicial separation or divorce if he is not interested to live with the spouse, or if respondent has proved that his reason was genuine, then he wins the case. But if the other spouse is not ready to accept this, court gives option to both the parties to decide on mutual consent that both the parties to stay separate. So court suggests for judicial separation for a certain period of time, as no court wants the marriage to get broken. So the parties also get legal remedy or legal protection against any civil or criminal proceedings. But if any of the party is not interested in staying due to any genuine reason, then the court can't compel him or her to stay together if other party has filed for restitution of conjugal rights. Then the court grants a decree for divorce when there is no scope remain to save the marriage. Court grants liberty to both the parties whether to go for judicial separation or for divorce. A decree of restitution of conjugal rights implies that the guilty party is ordered to live with the aggrieved party. Restitution of conjugal rights is the only remedy which could be used by the deserted spouse against the order. But under no circumstances the court can force the erring spouse to consummate marriage. This is all for restitution of conjugal rights. In case you guys have any doubt regarding the topic, so you can write in the comment box. Thank you. Stay safe.